Good evening. Hey there, I'm John Hartness. I am your host for The Writing Life. I'm a fantasy and urban fantasy and horror author. I'm also the publisher of Falstaff books and a cast member of the Authors and Dragons live play D&D podcast. You can look all that shit up online when you're done listening to me babble about publishing. We're going to call this episode Underqualified Advice as a tribute to my friend Drew Hayes, who has just released a book, possibly the most inaccurately titled book on writing ever, because it's called Underqualified Advice, and Drew is nothing if not qualified to talk to you about writing and publishing. So, because I'm going to talk about contracts and legal things, and I'm not an attorney, this is my underqualified advice video. We're going to start by saying that I'm not an attorney. I do not play one on television, so please, 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 please consult an attorney when dealing with contracts. Preferably an IP attorney. IP stands for intellectual property. Now, attorneys are kind of like surgeons. They specialize in shit. I don't want a contracts attorney handling my criminal defense case. For the record, I haven't been arrested for anything, so there is no criminal defense case. I also haven't done anything. I haven't even done anything interesting, much less anything criminal. So there won't be one. But my point is that when it's time to look at a publishing contract, make sure that the lawyer that you hire handles publishing contracts. This should almost certainly be a different attorney than the one who handles the closing on your house. And that should also be a different one from the one who drafts your will. And that should be a different one than the one who handles your divorce. I hope you don't get a divorce. I hope you don't die. Whatever. Get an attorney that specializes in what you want them to deal with. So when you are presented with a publishing contract, here's a few things that you should absolutely always know. 1, the publisher is going to skew all of the rights to the benefit of the publisher. That's their job. I write contracts to publish books. I work very diligently to make them fair, but I'm looking out for the company. Your job is to look out for you. For example, I sent out a contract to an experienced author about, Ruby Tuesdays. Not so good coming back with the bourbon glazed chicken. So I sent out a contract to an experienced writer with, 40, 50 novels out there. And this contract is for a collection of 4 novellas. It's our standard stock contract. And I tend to send out the stock contract before we really lock into a deal. That author's agent emails me back. Some things are marked out. The agency has a payment clause that they insert that includes where I'm actually sending the check. A couple of things about I'm sending X number of author copies to the author. Also, please send 2 copies to the agent. Fine. Then we get to audio. We do audiobooks. We try to do audiobooks for everything. Now, some agents and some authors have direct connection with audiobook publishers and audiobook producers. They may want to hang on to those rights. That's where negotiation comes into play. The agent, because her job is to negotiate for her clients, and she felt that she could make more money for her client if they held the audio rights, asked to not grant me audio rights. I want the audio rights, so I said, I'd really, really like audio. And she said, how about we put a sunset clause in the audio rights. I said, okay, that seems fair. What that means is that from the time the book is published in its first published form, be it ebook or print, I have 12 months to make an audiobook. If the book's been out for a year and I have not produced or at least contracted for production of an audiobook with a producer, then the rights automatically revert to the author. They don't even have to send me a letter. They probably will, because I have a good relationship with this writer and a good relationship with the agent. But they don't have to. The rights automatically revert if we have not exercised them. That seemed like a valid compromise, because both parties had a path to selling those audiobooks. I recently received a contract for a story that had audio rights in the contract. And I went back to the publisher and I said, audio rights were not part of this contract. This was not something that was negotiated ahead of time. You can't have audio. And the publisher said, I really want audio. And I said, I just looked through your catalog. You've never produced an audiobook. You're not getting audio. Because only one of the two parties negotiating had a history of producing audiobooks, I was in a stronger position to negotiate, and I could still be reasonable. So what you want to know is that the publisher's job is to benefit the publishing company, and everything's negotiable. Everything is negotiable. I know multiple people who have differing ebook percentages in their contracts with various publishers. Stephen King gets a higher royalty on print than I do in my books with Bellbridge. Stephen King makes his publishers a fuck ton more money than I make for Bellbridge. He makes more money than a lot of people. He has the stroke to ask for those terms. More to the point, his agent has the stroke to ask for those terms, but it's because Stephen King sells a shit ton of books. Everything is negotiable. I have included escalator clauses in some contracts when the author has a history of strong sales and they say, I really sell a lot of paperbacks. I want my percentage to bump up if I hit a certain number of paperbacks. Okay, that seems fair, because if you sell that many paperbacks, I'm making enough money to give you a slightly larger piece of the pie. We haven't had to hit those yet, and I really hope that sometime we do. But the one thing that's triggered this video, and the thing that is so important, is a little bit, just the slightest understanding of copyright. Okay, settle in, kids. This might take a minute. 1, you do not have to register a copyright to be protected by copyright law. It does cost money to register a copyright. It does take a long time for them to get through and process the registration of copyright. You are legally protected by copyright law from the moment your work is fixed in a form. I typically tell people, soon as you hit save, you're good. It may even be vaguer than that. It may even be once you've typed the words. I revise a lot, so. But if someone hacks into your computer and publishes your magnum opus out from under you, you're still protected, because there's a digital timestamp on that file. You can prove in a court of law that it has been protected. You are protected by copyright law. You do not ever sign away your copyright. I know, some of you are out there thinking, yeah, but I heard this. Yeah, but I heard this. Yeah, but this publisher asked me to do this. Yeah, but this publisher. You do not sign away your copyright. Ever. Your copyright is what says that you own the intellectual property. When you sign a deal with a publishing company, you are not giving them your copyright. You are not signing over your copyright. You are not selling your copyright. The copyright belongs to you. If you look in any Falstaff book, you go to the copyright page, it will say, copyright 2000 whatever teen, author's name. We, as a publisher, do not hold the copyright. You, as an author, do not give up the copyright. Audiobooks. If you listen to a lot of audiobooks, you'll hear, let's say, Salvation, copyright 2019 by John G. Hartness. Audio recording, copyright 2019 by Tantor Media. They hold the copyright to the audio production of my copyrighted words. I entered into a licensing agreement with them to produce and sell the audiobooks and pay me a share. They don't hold the copyright to the words. I don't hold the copyright to any book I've published that I didn't write. Don't sign away your copyright. Ever. Ever, ever. Yes, work for hire is different. You may not own the IP. I haven't done work for hire. I don't know enough about work for hire. That's a whole different kettle of fish. Most of you, if you're beginning writers, you also aren't dealing with work for hire either. So don't read a bunch of blogs about people who do work for hire and then think it applies to you. It doesn't. It's like me talking about publishing nonfiction instruction manuals for how to change the oil on a 67 Chevy. I don't do that. So I don't give a fuck what you have to do with the pictures of a 67 Chevy to put them in your book and be legally clear. It doesn't apply to what I do. I was talking with an author earlier last week. There was a map in her book. She drew the map. So when she sold foreign rights, she could use the same map without having to go back to either the publisher or the map creator and pay extra money. She held the copyright on the map. If her publisher commissioned someone to draw that map for them, that original publisher may have owned the copyright to that map. If the map maker held the copyright and licensed it to one publisher, then that map maker holds the copyright. An author doesn't have to go to first publisher, author has to go to first map maker. Hold on to your copyright. No reputable publisher will ask you to sign over your copyright. That means that if a publisher asks you to sign over your copyright, they're not fucking reputable. Don't work with them. Walk away. Over the course of these videos, we'll go into more things about when publishers go bad, what things not to look for and not deal with or put up with in contracts, and we'll get into some more of that over the months and weeks and years as people message me things on Facebook or email me different things that make me go fucking ballistic because some douche nozzle is out there trying to actually do this to people. Don't let people fuck you. Well, Okay? Don't let people fuck you out of money. What you do in the privacy of your own wherever is your goddamn business. I'm not going to fuck you because I'm a married man. Yeah, you didn't care about any of that, whatever. That's what I've got for contracts and copyrights, part one. Part one of 5 million. Hold on to your copyright. Don't sign that shit over. That's your long-term proof of ownership of the intellectual property. And any publisher who asks you to sign over your copyright is a fucking criminal. Don't work with them. As always, I am not an attorney. I do not pretend to be giving out legal advice. Consult an IP attorney every time you need to deal with intellectual property legal shit. All right? We good? Don't let people fuck with your money. Don't fuck with other people's money. Be good to one another. All right?